This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about what happens when you fail to pay a premium and receive a notice of cancellation, because there is never coverage after failure to pay premium before the 10-day notice to cure a cancellation goes by. In a first-party automobile negligence action, defendant USA Underwriters, USAU, appealed the trial court's order denying its motion for summary disposition, even though the policy had been canceled 6 months before the accident. In Cynthia Jackson versus John Doe and Eddie Jennard and USA Underwriters, the Court of Appeals of Michigan, on September 19, 2024, found and resolved the dispute by applying not only contract law but Michigan statutes. USAU provided auto insurance coverage to Willie Jackson to provide auto insurance, including uninsured motorist benefits, from January 6, 2020 to July 6, 2020. USAU issued a notice of cancellation on January 9, 2020, 3 days after the policy's inception, because Willie Jackson failed to pay the premium amount owed of $980.58 on or before January 8, 2020. The notice stated coverage would terminate unless USAU received the minimum amount due before the cancellation date. The cancellation date was January 19, 2020 at 12:01 a.m. The reason for cancellation was non-payment of premium. Willie Jackson failed to pay by the due date. The policy was canceled, and USAU concluded there was no coverage on the subject vehicle from January 19, 2020 to December 7, 2020. On June 2, 2020, plaintiff Cynthia Jackson was a passenger in the LeSabre, owned by her father, Willie Jackson, and was allegedly injured after being involved in a motor vehicle accident. In 2023, plaintiff filed suit seeking no-fault uninsured motorist coverage from USAU. USAU moved for summary judgment, arguing the policy of insurance was canceled as of January 19, 2020 for non-payment of premium, and there was no policy with USAU under which plaintiff could bring a claim for uninsured motorist coverage. The trial court denied USAU's motion, concluding the cancellation date was ineffective because the language in the notice of cancellation was conditional. USAU argued Willie Jackson failed to pay his bill. USAU argued providing Willie Jackson with 10 days' notice did not render the cancellation notice conditional or otherwise ineffective, but was just required by statute. He got 10 days of free coverage. The statute provides a termination of insurance shall not be effective unless the termination is due to reasons which conform to the underwriting rules of the insurer for that insurance. Close quote. This is MCL 500.2123 paren floor close paren and MCL 500.3020. The objective of the statute is to make certain that all of those who are insured under a policy are afforded a period of time, 10 days, either to satisfy whatever concerns have prompted cancellation and thus revive the policy, or to obtain other insurance, or simply to order their affairs so that the risks of operating without insurance will not have to be run. The insurance contract in this case allowed cancellation during the policy period by USAU under certain circumstances, including, in relevant part, the non-payment of premium. The language of the cancellation notice was peremptory, explicit, and unconditional. The notice of cancellation provided Willie Jackson an opportunity to cure, that is, make the payment within 10 days to avoid cancellation, but did not render the notice of cancellation conditional. It was just giving him a chance to cure his error in failing to pay premium. The condition already occurred when Willie Jackson did not pay the premium on its due date, and the USAU cancellation notice was valid under the statute. Because USAU complied with the statute, the insurance policy was canceled on January 19, 2020. Even when reviewing the evidence in the light most favorable to the plaintiff was not entitled to uninsured motorist benefits under the USAU policy because the policy was canceled on January 19, 2020, and was not in effect on June 2, 2020, when the accident occurred. USAU was therefore entitled to a reversal of the trial court's order, and the Court of Appeal did so and remanded the case back to the trial court, directing it to enter an order granting USAU summary disposition. In my opinion, and that of the court, insurance is a contract. The USAU contract, like every insurance policy, required the insured to pay a premium for it to be effective. Mr. Jackson did not pay the premium, and the policy was canceled in accordance with the policy condition and Michigan statutes. The plaintiff had the chutzpah to seek coverage on a canceled policy, seeking benefits without fulfilling the required condition of paying a premium. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who subscribes and by going to and clicking on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll also gain access to the more than 4,900 blog postings. You can also subscribe to these videos on youtube.com and on rumble.com. They're free. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.